Okay, thanks. I'll keep the introductions coming. We are going to get started so as not to waste any more time. I think you all know me by now, but my name is Molly Coleman. I'm the executive director of the People's Parity Project, where we are organizing lawyers and law students to unrig the law and build a legal system that works for working people, not corporate power. We are so excited to be at the culmination of this reading group that we have been organizing for the last 6 months with the Law and Political Economy Project. I'll do my regular logistics spiel in just a second, but before diving into that, really want to take one moment to just thank you all for being a part of this. As we approach the end of June and just like the constant nausea and fear sets in that I think we all live with every June, it's been really a source of hope for me thinking about what this reading group has been over the last 6 months, thinking about the literally hundreds of people who have spent random nights throughout the winter and spring coming together to think about what could be other than this current system that we have, to think about how we build power to change the legal infrastructure that currently exists and what that might mean for our ability to fight for a better world. It's like still really bleak, and I think we're going to spend a lot of time tonight talking about how truly bleak things are, but it also is it's a really real source of hope, and I think really exciting to see how energy around the fights that we are taking on here has built over the last 6 months, and really so excited for what's to come and to be a part of that with all of you. So just thank you. It's been such a thrill to organize this with Corinne and the team at LPE and to be a part of it with everybody who's here tonight. So that said, we're on our final session. I think that you'll probably know how this works, but in just a moment, I'm going to turn things over to Corinne. She'll introduce our two speakers who we are incredibly excited to have joining us tonight. Then we will hand things over to Astra and Sabeel. They'll take us through the better part of the next hour in a back and forth conversation. So a little bit of a different format than we've had in past sessions. Once we conclude, if you are participating in either an in-person reading group or discussion group or a separately organized discussion group, hop off. You are done with us. If you are sticking around for the discussion sections that we organize, stay on. You'll get sent to those breakout groups momentarily, and then those rooms will close at 9:30 Eastern. The last thing that I want to be sure to mention, every single week we have sent you a feedback form, or every single session we've sent you a feedback form. This session, it's especially important because it is our final session. And so you'll see a couple of questions on there, the same ones as always about tonight's session, but you'll also see a couple of questions about the reading group as a whole, what's worked, where we can improve, whether or not you would recommend something like this to a colleague, a classmate, a coworker. We really, really, really would appreciate your time in filling that out. This is the first time we've done something like this. We're excited about it, but also want to know how to improve if we were to do something like this in the future. So your time filling that out is always appreciated. Tonight, it is appreciated even more than usual. I think that is all I have on logistics. So with that, I will turn things over to Corinne.
Thanks so much, Molly. And just wanted to reciprocate the fact that it's been a privilege working with the People's Parity Project. As Molly said, I'm Corinne Blaylock. I'm the executive director of the Law and Political Economy Project. We're a network of legal scholars, students, and practitioners developing scholarship and pedagogy to democratize our political economy and work towards a more just, equal, and sustainable future. And tonight it is my privilege to introduce two extraordinary speakers. Astra Taylor is a writer, documentarian, and organizer. She's a co-founder of the Debt Collective, an organization doing amazing work to cancel student debt, as well as medical, carceral, and housing debt. Astra is the author of a number of books. I'm particularly fond of Democracy Might Not Exist, but We'll Miss It When It's Gone, and The Age of Insecurity, Coming Together as Things Fall Apart. And this year she co-authored Solidarity, the Past, Present, and Future of a World-Changing Idea with Leah Hunt-Hendrix, a chapter of which we included as part of tonight's session. And also joining us is Sabeel Rahman, a professor at Cornell Law School. He is a co-founder and faculty co-director of the Law and Political Economy Project with me. His academic research focuses on issues of democracy, governance, and economic power. From 2018 to 2020, One, Sabeel served as president of Demos, a national racial justice think tank and advocacy organization, and more recently served for 2 years in the Office of Information and Regulatory Affairs, otherwise known as OIRA, where he played a lead role in the Biden administration's efforts on equity and reforming regulatory analysis. Sabeel is also the author of a number of books, including Democracy Against Domination. Thanks again so much to everyone for being here tonight, and particularly our speakers. And without further ado, I will hand things over to them.
All right. Hello, I'm Astra. It was agreed that I'd maybe kick things off a little bit. But I thought I was supposed to see Sabeel. I'm only seeing myself. But there you go. So my name is Astra Taylor. I'm really happy to be here. Grateful to be in this community. This is such an important issue. I'm going to focus on my work with Debt Collective, which, as Corinne mentioned, it is a group that has been leading the fight for student debt relief and other forms of debt cancellation. We are the first union of debtors, and we're an experimental formation. There haven't been debtors unions before. And we have been in the belly of the beast, fighting with the courts. And so I'm going to get a little bit into the weeds on our experiences, hoping that it sort of probably sheds lights on other people's fights and really what the stakes are, and what's happening, and what's being done wrong, and how we can maybe fight better and smarter in the future. So I'm just going to do my version of narrating our movement and some of the legal battles with the proviso that I am not a lawyer. So I'm going to feel extra ridiculous saying lawyery things. The Debt Collective has its origins in the Occupy Wall Street movement. So going back to 2011, and that was where we first started calling for full student debt cancellation and free public college. And so I think it's important to begin with the fact that, our organizing didn't begin with what was legally possible. It began with what we felt was morally right and necessary and urgent. And that's what we need to do, right? Is to open the sort of imaginative horizon, the political horizon, to start shifting the narrative. And then we started thinking about the law and how we could use it as a tool in our organizing, but we did not begin with the law. And I think it's actually really important. It's just important to just kind of be bold enough to be like, this is right. This is what needs to happen. In a way that the law is sort of secondary. And once we started making this call for full debt cancellation, we then, one of our co-founders is Luke Karen, who people in this community probably know, who is now a law professor and involved with LPE, who began with other lawyers who had been working on consumer debt issues and student loans, began to figure out what were some of the legal mechanisms by which student debt could be canceled. So the law is something that we did keep bumping into, and it's something that we've had to engage with. And so, what an early example of this, one of our first campaigns out of Occupy Wall Street was something called the Rolling Jubilee. So we were the group that sort of figured out how to buy debts on the secondary debt market, unsecured debts. So portfolios of, for example, payday loans or credit card debts, and mostly medical debt, and cancel it. But immediately, not only was there the challenge of engaging with shady, speculative debt collectors, but also there was the fact that debt cancellation counts as income, according to the IRS. And we did not want to cancel people's debts and then have them get hit with a tax bill. So what do? Well, we were like, let's figure this out. Let's find ways for this to not be the case. So we ended up, because we were getting a lot of media attention, attracting the interest of one of the leading corporate tax attorneys in the country, who then put on his sort of creative lawyer hat, even though he wasn't somebody who was a comrade, right? And he was like, well, actually, there are legal arguments to be made for why the cancellation of debts that are in collection shouldn't count as income. And so, right out of the gate, when we were just kind of, beginning to come together as a group, we were already pushing the boundaries of the law. And over the last decade, that has become sort of established, legal theory, right? So now there are other groups that are canceling medical debts. Governments now are partnering to cancel medical debts, and people are not getting hit with a taxable income. So right there, we're already sort of expanding legal interpretation. And doing that because there were lawyers who were ready to kind of collaborate with us, to think outside the box, to use their sort of legitimacy and expertise, the fact that they were working at these corporate firms, and like get behind us and work with us on that. So we right away learned that the law is sort of political terrain we need to fight over. At that point, though, but now the issue has moved into more being sabotaged by the courts, and so we're dealing with the law in a very different way. I guess before I get further into this, I just wanted to say, on the subject of the courts, is like, which courts are we talking about? So people here will probably be familiar with the fact that President Biden's student debt relief plan, which we helped push him to implement imperfectly, has been stymied by the Supreme Court. I'll say more about that. But when you're talking about debt, we're also talking about small claims courts. We're talking about just, the court, local courts that are basically hijacked by debt collectors. The debt collective also works on rent debt. So we're talking about housing courts. So we're dealing with the law and with courts at different levels, and trying to figure out strategies that apply to whatever level we're working at. And then I think there's like the ultimate court that we're trying to appeal to, which is the court of public opinion. And that court really matters, because what we've seen is when we start to change the way people think about what's possible, what they're entitled to, what's morally just, that actually has political consequences. So I think right now people assume you should be able to have your medical debt canceled and not get a tax bill, right? It's not just that we want a kind of legal argument, but we've also just established a kind of precedent in the public imagination about that. So I think that that aspect, actually the power of changing like sort of public assumptions, cannot be understated. It's really important to bring people along. And so I want to give some examples of how we've done that. And then there's of course this sort of, along with public opinion, there's sort of expert opinion. Who are the policy experts? What are they thinking? And I think the Debt Collective and our allies, and there's lots of other groups I could name here, have shifted the way that certain bureaucrats, specifically in the Department of Education, think about the law and think about how to interpret different statutes. And have pushed them to be bolder. So I'm going to quickly give a history of the Debt Collective and some of our battles. So after the Rolling Jubilee, or actually kind of coming out of it, with the Rolling Jubilee, we bought and erased millions of dollars of medical debt, and we ended up buying a portfolio of debt that was tuition debt from a predatory for-profit college, a chain called Corinthian Colleges Incorporated. So we erased debt these were private, this was like tuition receivables held by these collapsing predatory for-profit colleges. And then we started reaching out to students who had gone to these schools and been defrauded and said, hey, we canceled some of your debt, but most of your student loans are with the federal government. We can't buy those and erase those. Those are not, sold on the same kind of secondary debt markets. You need to actually organize. We need to organize together and actually demand that the federal government cancel those debts. And again, working with Luke and with other lawyers, we found that there was something called borrower defense to repayment, which was a provision and a little known provision in the legal code that basically said, if you have attended a college that has violated state law, then you are entitled to debt cancellation. So this is one of our recurring methods, which is to find rights that people have on the books, rights that are being trampled, and try to organize around those, try to politicize them, try to actually get people to engage with the law collectively instead of individually, and then use that as a leverage point to demand more. So we worked with lawyers and created an application that we thought would be a borrower defense, approximate what a borrower defense application should be. We ended up overwhelming the Department of Education with these legal claims and getting a trickle of debt relief. But here's the thing, the Debt Collective from the beginning, working with students from these for-profit colleges, was saying, we demand automatic full cancellation for folks who have been defrauded. There's no reason for each person to have to apply individually. We can do something much bigger. We can do automatic big buckets of cancellation. Every student who went to the school, they should just get their debts canceled. The school was systematically defrauding people, and there was tons of evidence from various states that this was the case. So this was when the Obama administration was still around, and they sort of refused to do the group discharges and instead kind of insisted on processing claims one by one and doing a trickle of relief, right? Flash forward to 2022, and Kamala Harris, who's vice president, she had actually been part of, as attorney general in California, she had done a lot of research on these criminal schools. She announces what? Full automatic cancellation for every Corinthian student. So in other words, what they had told us was impossible. You'll never get it. You'll never get a penny of relief. You'll never get a group discharge. That's legally impossible. Well, 7 years later, they finally did it, right? What happened in those 7 years? Well, Trump was in office and Betsy DeVos was the Secretary of Education, and she was determined one of her top priorities was to destroy borrower defense, and to, so made people suffer for another 4 years. But my point is that we changed not just their interpretation of the statute, but their whole approach. Like suddenly automatic group discharges possible when they said it was impossible. Billions and millions of dollars of relief, changing the lives of millions of people. So this is the bulk of the cancellation that the Biden administration has delivered over the last 4 years. So learning lessons from our experience with borrower defense, we also started talking about broader student debt cancellation, not just for people who had been defrauded, not just for people whose schools had broken state law, but the fact that through the Higher Education Act, which originally was passed in 1965 and has been reauthorized, but in the Higher Education Act, there is the ability to compromise and settle debts, right? That actually the president has broad authority to cancel debts. So while we're building a movement of debtors demanding this, we're also part of it isn't just sort of getting debtors together and meeting and protesting and stuff. We're also trying to blast this fact out into the ether, and again to win in the court of public opinion. And part of that is making the moral case, like why student debtors actually deserve relief. There's all sorts of things to be said, but other things were just like this. This is a link to a page. And I think if you open it up, it actually says "fuck the courts," which is good, which was where we were at that moment. But what we did was we wrote an executive order that President Biden could sign, invoking this authority. And of course, we know the president is not really going to sign our executive order, right? But what we're trying to do is show the public that it's possible, that all it takes is the flick of a pen. And we started saying this: with the flick of a pen, the president has the authority to cancel this debt. And the next thing you know, Chuck Schumer's saying flick of the pen, and Elizabeth Warren's saying flick of the pen. And we're just getting this idea out there that it's easier than you think to cancel debt. So of course, Biden eventually does, say he's going to cancel debt up to $20,000 of debt for people. He does not end up using the Higher Education Act. He ends up using another totally fine legal authority. But the problem is that the Biden administration insisted on means testing relief, which meant that they had to have an application. So this is echoes of the Corinthian situation under Obama. So people had to individually apply for the Biden cancellation plan. It took them 6 weeks to put the application online. So what happens? Exactly what we warned them about, which was that there'd be a bunch of bad faith, billionaire-backed right-wing lawsuits trying to stop their relief plan. And the point is, and what we were saying, and we said this to the White House, we said this to everyone who would listen, is it wasn't a matter of legality. We weren't saying they weren't smart. We weren't saying that their legal theories were wrong. We were saying that they were up against people who were going to weaponize the law and weaponize the courts, find some sympathetic judges in whatever state and get this plan blocked. And so by doing the means testing, by doing an application, by slowing things down, instead of canceling debt broadly and automatically, as they had finally done with the Corinthian students, they basically opened themselves up to this litigation. And eventually, there were lots of cases. Most of them were thrown out. Most of them couldn't find a way to be heard. But eventually, one of the cases stuck, and the Supreme Court ruled that the program under the HEROES Act was illegal. And so, I think two things for this group are interesting. One is the Supreme Court majority invoked the major questions doctrine, which is, to even call it a doctrine is to dignify it. It's basically saying this question is too big for anyone but us to decide. We, the Supreme Court, should have the final say over this. It makes it sound very serious, I suppose. It just is, bullshit, in my opinion. And they had to really twist themselves into knots to find some plaintiff that had legal standing. So eventually they claimed that a student loan servicer called Mojilo, which is a quasi-public entity, anyone with student loans probably knows it, out of Missouri, that basically, they claimed that Mohila would lose revenue, and therefore Mohila would not be able to pay a debt back to the state of Missouri. And so that's why it had standing. Now, the debt collective actually had to debunk. They did a white paper, which I'll also post in the chat, debunking this, because it turned out there was never any discovery. There was never any real hearing of the evidence. These claims were never fact-checked. And in fact, the Mohila was actually going to increase its revenue, and there was no sign it was ever going to pay back this debt to the state of Missouri. But the point is, the standing claim was there, and they found a way through this entity. So it doesn't matter. Of course, the liberal justices were mad. They said this decision violated the Constitution, whatever. It doesn't matter. So here's the thing. Because of our organizing, Biden, the day of this Supreme Court, and I'm going to be fasting it out of this, but Biden, the day of the Supreme Court decision, President Biden does have a press conference that says, I'm going to do a plan B. I'm going to use the Higher Education Act. So that is something that, is, I think, a victory for progressive movements, because Biden actually said he's going to cancel, he's going to push back on the courts. Once again, we are trying to push them, okay, learn from your mistakes, cancel the debt boldly, automatically, make the right wing fight us, make them fight to reimpose the debt, right? Fight from the high ground instead of tying your hands behind your back. But they insist that, they insist on doing a slower way that once again opens up room for bad faith lawsuits. Meanwhile, they announce a new iteration of a very old, everybody has over decades has had income-based student loan repayment systems, student loan repayments programs. So they announce a new version of this called SAVE that is a better, for some people, version of these income-driven repayment plans. And they say, okay, well, we're going to do this at least to kind of try to move the needle on student debt relief. And yesterday, so yesterday, actually, two courts simultaneously issued injunctions against this SAVE program, which is a new iteration of a longstanding income-driven repayment system. Why does that matter? One, it shows that the courts and these right-wing plaintiffs are not just going after some novel debt cancellation program. They're going after longstanding existing programs. They're going after the administrative state, right? So it shows the stakes, right? This isn't just like, oh, we activists got greedy and asked for more and that we're being shut down. It's like, no, this is actually just a prelude to going after the possibility of any kind of student loan relief. Once again, these injunctions were issued, based on incredibly, troubling arguments. So states losing revenue from future tax income, just arguments that make no sense. Mohila, once again, is invoked in the Missouri lawsuit. So this loan servicer that, again, is a kind of quasi-public entity. So really, it's, essentially, and then also the states are positing that student debt cancellation will reduce their ability, the states ability to retain employees because they won't have the lure of public service loan forgiveness hanging over them, right? So essentially, they're saying that, these loan servicers are entitled to profits. The states are entitled to indentured labor, but borrowers are not entitled to student debt relief or even like more modest payments. And I think it's also really important to note that it was two Obama-appointed judges who issued these injunctions. So what we're seeing is the trickle down of right-wing legal theory, sort of, right? That you dress something up in the major questions doctrine, you dignify some stupid fucking argument by saying, oh yeah, that Mohila has standing, and the Supreme Court does this. And next thing you know, liberal jurists at lower levels are echoing them. And that's how we sort of keep losing ground and the center doesn't hold, right? So here's the thing. We have, what I've learned in this experience, I think my debt collective colleagues have too, and many other people who are our allies, is that there were many things along the way that could have been done that would have been bold. These are the lessons for what we do, how we deal about the courts. So what could they have done and what could they still do? They could have canceled debt universally, swiftly, automatically, no paperwork, right? And deliver on their promise and then dare the Supreme Court to reimpose the debt, right? I mean, they don't have the police force. They don't run the student loan servicing machinery, which, believe me, is messy machinery. It would be hard to reimpose debt that's been canceled. Once the Supreme Court did stymie the first debt cancellation plan, and President Biden said, "I'm going to do a Plan B with the Higher Education Act," he could have done it with an order instead of going through a whole negotiated rulemaking slow process. Again, they could have learned from their mistakes, done it fast. What could they do now? They can, so the debt collective is pushing for Mohila, the loan servicer, to be fired. Why? Well, because they have a whole astonishing history of bad management. For example, they are engaged in something called call deflection schemes, where to get rid of unhappy borrowers, they keep you on the line for 9 hours. They're a horrible company, lots of reasons to fire them, but also you get rid of them, you fire them. Well, then the whole standing argument goes. So we've been trying to raise awareness about the demand to fire Mohila. We've gotten many representatives on board with us. I'm sharing a video of us disrupting a student loan servicer convention where we are calling on them to fire Mohila. What else could they do? We've recommended, for example, that the Department of Justice respond to some of these cases by saying, let's take this to the Court of Claims. Let's settle this as a contract dispute, not a constitutional debate with major questions at stake. This is just like a contract's being renegotiated. Let's try to lower the heat, right? And also just send a message to the public that this really isn't a big issue. This is a loan servicer that just wants to be greedy, and Republican attorneys generals taking advantage of the situation because they have a political agenda. So put it in the Court of Claims, take it out of the Supreme Court. Even if that doesn't work, it sends a message. What we're also saying now is, fine, they're going to pass these injunctions. They're going to issue these injunctions and shut down this SAVE program that serves 8 million borrowers and probably shut down Biden's Plan B. Well, then what the President Biden and the Department of Education can do is shut down the entire student loan servicing system. They can issue a new pause, like a payment pause, sort of what was around during COVID, using the Higher Education Act. So the message is, be bold, fight, and you may not win, but you could lose better. And so that's where I want to hand this to Sabeel, because I think this thing is, what does it mean to win? What does it mean to lose? And can you lose in the right way? Can you lose in a way that at least shows that you're standing up for something, that engages in public education, that buys you time, so that you can do other sort of technocratic things that maybe deliver relief through other legal means while you're buying time, for example. And, because if you lose by trimming your own sails and trying to fit into the box that's created by your adversaries, you legitimize them and you get into this problem where we keep losing ground. So I think for us, the student debt fight is kind of wonky. Honestly, it bores me to death, but it's an example where along every step along the way, there was a way to be bold. There was a way to do this right. There was a way to be on totally different footing. But the people in charge just seemed determined to fight like it's 1992 or something like that. And we need to also shift that mindset.
Yeah, that's tremendous, Astra, and so appreciate you sharing kind of from in the weeds and on the front lines. I think usually a lot of folks are following and thinking through. I want to pick up where you just left off on this question, especially if you're pushing for like the morally just right North Star, that's not going to go through, in the first instance. And so how do you play the long game and move, change public opinion, change what people expect as what is just ordinary entitlements that we're owed to one another, and your story about the debt collectors work really highlights that. I want to kind of pick out a few things. So I think the story you just told, I would wager, is very similar in its kind of basic structure on a number of other issues, right? So if we were to run through the fights that we're having on climate policy and the role the court is playing on climate or on racial justice, or on LGBTQ rights, on reproductive rights, or on any one of a number of things. I think this back and forth and the trimming of the sails risk that you're describing, I think shows up there. And, as Molly mentioned, we're on the cusp of what will be a very long Wednesday and Friday in terms of decisions coming out from the court. So, we're going to have to like reload for a long haul going forward. So I do think this is going to apply in many different issues. I think on this question of losing well, in your story, you mentioned a couple of things I want to draw out, and then I want to kind of toss back to you sort of what else does losing well or thinking strategically about the longer arc of transforming our democracy look like. So the first thing you raise I want to mention is you articulate two different terrains of contest. The sort of broad, well, many different terrains of contest, but in particular, the broad like public narrative. What can we start from a clear moral vision and articulation so that the public comes to think and believe that they're owed things that they're genuinely owed, right? And that the way things aren't the way they ought to be or the way they need to be. That's different from the elite organizing or the kind of organizing the wonks, folks in government or folks in courts or people who are clerking or what have you, to sort of I feel that they have some legal arguments behind their back. There's some branch to stand on, and those it seemed like there's an important complementarity there. But I wanted to tease that out in terms of when does that really work and when does it not work, right? That kind of elite and mass organizing at the same time. I think the second thing that I wanted to draw out is when I was trying to think about sort of what role the courts and law is playing in the story that you're telling. And I think they're a barrier in two different senses. And one is that the kind of like maintaining an existing status quo that is actually unjust, but seems natural and normal. So before the initial call for Jubilee, right? This idea that, well, the debt is just what it is, and we have to deal with it and we have to live under it. The first part of your story is great sort of retelling of how that notion was denaturalized, right? That like just because that's what the law is doesn't mean that's what it has to be. But then the second part of your story is I think a different challenge of like law as reactionary counterstrike, right? So even once we've won the kind of broader public argument about like, yeah, we shouldn't have medical debt, that's absurd. Then we have to contend with this sort of the reactionary power that these many different courts are able to exercise to roll back that progress even before it's really come to fruition. And that's I think those feel like two different problems. I'm curious how you think about that. And then the last thing, I know I'm throwing a lot at you. I think this towards the end you were saying something about you mean sort of fighting like it's 1990 as opposed to 2024, and I'm curious to what extent you feel like in the many different conversations you've had with folks at different parts of the ecosystem, how much is the bigger barrier, on substance, like people who just, they're not as progressive, they maybe are not as sort of oriented towards fighting inequality or economic justice and to have more of a traditional view of economic policy, versus people who have a different view of strategy, that they might like the idea of the policy, but they, think that the way you get there is by, dotting the I's and crossing the T's, and you get points for being the good faith actor, and if the other side is not the good faith actor, then you kind of, that's the moral high ground that I think you often see folks wanting to claim. And so I'm curious, in your various interactions, which of those has felt like the bigger challenge or barrier, right? Like if someone who is maybe with you on the policy but not willing to test the boundaries of the existing norms, versus someone who might be game to throw down against the courts but maybe just doesn't agree with you on the policy.
Yeah, okay, great. I mean, I'm curious to hear your thoughts on these things. I mean, working backwards, I mean, I think, we have run into the problem of people who claim to be with us on the policy, but aren't willing to fight aggressively. And so this,
right.
I was talking to our friend Mike Pierce, who's the executive director at Student Borrower Protection Center, and we were commiserating over these injunctions earlier. And it's like, we're tired. We don't want to be right, right? And I just mean right that the courts aren't going to let this happen. We want to win. We want people's lives to be improved. We want to fight more interesting battles than just for student debt cancellation, right? And I think there is still a class of people and people who have kind of climbed the ladder and are at the Department of Justice or wherever, who don't, who maybe do get more kudos from dotting the I's and crossing the T's and trying to be the adults in the room or appear as such, but who are actually undermining their own stated aims, right? I mean, so this is what and the debt collective was not alone. We warned many people that by having this application, they were opening themselves up to all of these risks. It was going to cause delays. It was going to cause, there were sort of technical concerns. There were these legal risks of these, lawsuits. And so what we tried to say is, you might not agree with us on substance. Like, we do want all student debt canceled and you don't, you like means testing, but actually your means testing, the fact that you're in all the bureaucracy it adds on is actually a risk. And we just haven't, I don't know what will shift that mindset, how many losses it will take, right? But I feel like that is, when you're talking about elite versus mass organizing, I feel like that's part of the elite organizing problem, is how do you actually convince people that to those adults in the room to govern responsibly is actually to do things like jurisdiction stripping, to actually sometimes do something bold and more universal up front, like canceling student debt and getting that cancellation in the accounts, so that you're fighting legal fights from a higher ground, right? Instead of doing a rear guard action where you're actually, ceding terrain in advance. So that to me is a real challenge, and something we just hit our heads against over and over again. And this relates to your other question about, the two phases, right? So one is a kind of phase of sort of opening up space, public imagination, making inroads, and counterstrike. And I guess I would just say that we knew the counterstrike was coming. All of us knew this. It's not that it was shock.
Right.
People were warning for decades that abortion was going to be taken away. I mean, so it's how do we, there are ways to play hardball that won't totally mitigate the threat, right? Because the right wing has captured a lot of ground in terms of the courts, and and they have infinite money to hire infinite lawyers. They're like monkeys on typewriters, But there are ways to just not cede so much terrain in advance, and I'm very grateful to be in this space, and the fact that people are talking to the next generation of law students to say, like, actually, how do we engage the political realities in a way that will have an effect. And to that, I just want to say that there's lots of ways for folks to help. The Debt Collective Student Borrower Protection Center is looking for folks to help them with their various initiatives. Today, I heard from some exciting people who have some need for legal help in the student loan space. The pitch was, if you're interested in using securitization against the system, I think there's lots of stuff to be done around medical debt cancellation as well. And then there's also elite, again, legitimization of what seem to be out there theories, right? Like, for example, the question of moving the cases against student debt relief to the Court of Claims, right? But why not? But that's such a grounded concept compared to some of these right-wing theories of legal standing and stuff like that, but we need movements, right? Our kind of mass organizing needs that legitimization of people who have the degrees, have the institutional affiliations, have the prior work experience to say, that we're actually making sensible, rational arguments against adversaries who are willing to wield power to the maximum.
Right.
Yeah.
Right. Yeah. So no, that's great for our audience to hear too, from someone in the front lines, right? That there are many different roles that folks can play, and one key piece of this is, how to help shore up or validate kind of and sort of design some of these steps. And I think your point about removal to a different court is also a good one, because I think a lot of times when we talk about like what is bold action, in some sense, bold action is calling for the whole thing, as you've said, right? Like the North Star is cancellation. But in another sense, bold action might be a small thing, like getting something to a different court. But it's a incremental step that's part of a larger strategy and vision, right? So I think it's not always you have to hit a home run every time you go up to the plate. Bunts and singles are good too, but it's got to be bunts and singles that are part of a larger strategy that is trying to get to the actual like big cancellation in this case, right? And I think that's also a helpful nuance for folks, is something like where can everybody plug in?
Yeah. And I think that, and just, right, that even if that was a loss, it would be losing potentially in the right way, because it would send a different message. It would buy time, and it would just show that you're willing to respond creatively, which is needed,
Right. I know we want to save some time for breakout groups. So maybe one last question. I wonder if you could say a little bit more specifically about the courts themselves and our aspirations for a democracy. You've written about this and thought about this for so long in terms of like, what is that democracy we are grasping towards that we don't have right now? And our whole theme this semester has been this question of what to do about the courts. But I'm curious, when you think about like what kind of a democracy you would want us to all live in together, where are courts in that, if anywhere, or what are the things you want to be sure to avoid, right? Like, do you have a sense of what to make of the judicial power in a democracy?
Yeah, I'm curious to hear your thoughts on this too. I mean, I think there is no panacea, right? I mean, so
right.
This is I think part of thinking a lot about democracy is, as you have as well, is there isn't actually one sort of procedural fix that will kind of give us what we want, because we can disempower the courts, which we absolutely should. And, Congress is marginally more democratic. I mean, it's significantly more democratic than the Supreme Court, which is really sad. But the Congress is not a space of democracy for all the reasons we know, the malapportioned, districts, the fact of just money in politics. So I think, I've been thinking lately in this, the chapter that we circulated is, part of this book on solidarity. And for me, I've been thinking more and more about sort of what are the precursors to democracy, and solidarity being one of them. So I feel like, we cannot underestimate the importance of these sort of mid-level organizations like labor unions, like potentially debtors unions, tenants unions, that help build the solidarity and the political consciousness for people to engage politically, because the procedures alone won't get us there. But I do think in this book on solidarity, my co-author and I sort of imagine what we call a solidarity state, which is sort of one step beyond a welfare state. And what we mean by that is a state that doesn't just seek economic redistribution and justice, but is conscious of the fact that we need to cultivate solidarity in a kind of sense that we're all in this together through our state policies. Because the right wing does this, right? So Margaret Thatcher famously said, the point isn't just economics, the point is to change the soul, right? So neoliberal economics was also about creating a sense of atomization, competition, scarcity. And I think we need to think about social policy as a means to do the opposite, to create a sense, again, of solidarity, of community, of interdependence, and so what would the courts be like in a solidarity state? I mean, I'm inclined to think there'd be a lot more sortition. So just like we do random jury selection, that maybe we'd randomly select some judges, because it couldn't get much worse. Create systems that have a lot more sort of participation on that level. But I do think the system we have now is obviously, deeply undemocratic. And I do think there is a moment to build a big coalition that recognizes that fact. Just, you were exactly right. What the Debt Collective is going through with student debt, every other movement is going through on their issue. And we do need to create formations and organizations that can help us act on that reality. And right now that is lacking. We're all kind of fighting these court issues in our silos. So I think a next step, and there are people who are then experts on the courts in their silos, and we do somehow need to break out of that and create something where we can work together and share tactics and politicize this issue more. But I don't know.
Yeah,
what do you think? Where should judges be?
No, I love that, and I love all of that, and I think you're exactly right that in some ways the biggest threat to my mind coming out of the courts as they're currently structured today is the threat to democracy itself, right? Both in terms of just they're counter-majoritarian institutions, as we've been talking about, but also like just thinking about the debt story, the way it the combination of far-right attorneys general, say, or litigants, well-resourced litigants, can leverage the judicial apparatus to strike at any collective movement for making our social society better, right? Whether it's the labor movement, the debt movement on reproductive rights, right? So it's an attack on democracy in this deeper sense, that it's frustrating our own ability to mobilize and organize and act in solidarity and and to make a different country. And that feels something, to your point, that is cuts across the different issue areas that we tend to maybe focus on, professionally or academically. And there's something there that I think we will all need to grapple with in one way or another over the next decade or so.
Yeah, no, I think that's right. It's not just that they're stymieing policy, they're also demoralizing the demos who are fighting for progressive change. I hate to let them win at that level too, because the fact is, people, this country labor unions were illegal at the beginning of this country as conspiracy doctrine of, British common law was imported, right? And people had formed unions anyway. And so we have to organize sometimes within, but also against the law. But yeah, I think there's a lot more coalition building and strategy that could happen. And I do think there's a lot of tools in our toolkit that could be used that could really frustrate the far right. And I would love to see them used more.
So maybe as a last word, if you want to say one more sentence about what that might be, and then we can give folks a little bit of time in breakouts.
I mean, I just think, learning, the Debt Collective, for example, we've learned a lot about, I think if we went back in time, we would be even bolder about saying, it isn't just that you have this legal authority, but that you have to aggressively, you have to create a sort of protection around that by doing the implementation in an aggressive way. And we sort of knew that, but now we know that even more. And I think there are lessons there for every fight. It's not enough for us to just sort of state the demand. We also need to be like, this is how you do it, given the fact there are going to be these right-wing attacks. So the legislation has to, again, have jurisdiction stripping, or, if you're going to issue relief, you do it swiftly. And I do think we can get smarter in those battles. And, that there are tools that we right now don't have the power to force the people in power to use, but they should be, part of what we're working towards.
Yeah, that's great. Boldness as a strategy, and having our own countermeasures to defuse the reactionary counterstrike ready in advance. All very, very important. Great. I think I see we're kind of close to the bottom of the hour. We want to leave some time for folks in breakouts. Astra, thank you so much for spending the evening with all of us. Any last comment or plug that you want to make before we send people off?
No, just if people are interested, join the Debt Collective anyway. But also, if there's people with legal expertise who do want to join the specific fight, and also, legitimize the organizers. Always, because it can get lonely out there in the trenches when you're demanding things that people say are impossible.
Awesome. Thank you so much, and hope folks will follow up on that call. Sending you off to your breakouts, and thanks everybody for joining us.
As you head out into breakouts, reminder to fill out the survey that we will drop in the chat one more time. Thanks, everybody.
Bye, Sabeel.
Bye. Thank you, Astra. More soon.
Good.